Hi, welcome to the Wife of Caesar. Happy Monday. My name is Michel Levien, or Michel Levien, either's fine. And as you know, the Wife of Caesar is Streiner's project where we try to talk about corruption or anti-corruption using normal words, using everyday speech, so that we can fight corruption in our day-to-day lives with a little bit more than just good intentions. Okay, so as in every episode, we will talk about a piece of news, a case, and a typology. In the piece of news, we discuss current events that may or may not be obviously related to anti-corruption. Sometimes the news is very clearly related to anti-corruption and sometimes it isn't. When it isn't, we will try to explain the nexus between that and anti-corruption and then give you our opinion. When we talk about a case, we try to take on cases that are either current or past cases but are somewhat related to the message we are trying to convey. And in the typology section, we talk to you about the concrete steps that people take to commit acts of corruption. Okay, so today's news piece and case are sort of merged together because it's a case that's been on the news forever and it'll be probably on the news for many years to come, or at least some months to come. But anyway, today we get to talk to you about Odebrecht yet again. This won't be the last time, I promise you. Okay, so to sort of do a small recap and give you some context, Odebrecht is a company from Brazil that does infrastructure and construction work for many sectors, including the energy sector. Now, this is Odebrecht. The Odebrecht case came to light as a part of Operation Jato, which is, or sometimes known as Operation Car Wash, which started in 2014 in Brazil. It's called Car Wash because Brazilian prosecutors were doing an investigation into money laundering schemes, and they figured out that one of the first breakthroughs in the case came when they realized that some public officials were laundering money via actual car washes. So, that's where he gets his name. Okay, over the course of the investigation, they realized that this scheme spanned over several countries, the most notable of which are Brazil, obviously, Switzerland, and the US. Now, when it came to the US, it gained most notoriety because of the violations to the FCPA, or the Foreign Corrupt Practices Act. It's just the US's anti-corruption law, or the US's law against foreign bribery. Within Lava Jato, of course, came Odebrecht, and Odebrecht was sort of, in a way, settled last year with a deferred prosecution agreement. As we've talked about before, a deferred prosecution agreement is just an agreement between the state's attorney or attorney general's office, essentially the prosecutors in the case, and the accused person in the case. And in this contract, or in this agreement, the accused person says, yes, okay, I'm fine. I freely admit my guilt in the situation, but in return for my admission of guilt, I would like a few things in return. Obviously, they also have to cooperate, and it's not as easy as it sounds, but it's a very useful tool, and it's actually fairly legitimate in many countries, including Mexico. Okay, that deal imposed on Odebrecht several conditions, one of which was to confess as to every aspect of their corrupt operations. And within those confessions came the confession that Odebrecht had paid around $10.5 million US to public officials in Mexico, and particularly in Mexico's energy and oil sector. Now, further, Odebrecht very specifically admitted to having paid a bribe of over $4 million US to a Mr. Emilio Lozoya. Emilio Lozoya was the director of Mexican Pemex, which is the state-owned entity that is in charge of oil and fuel in general. Today, Mr. Lozoya is no longer part of Pemex, but he also has not been prosecuted for his alleged crimes. Why not? Let's get into it. Okay, between 2017 and 2018, the Prosecutor General Office in Mexico, this is a tricky name, it's kind of weird to say it in English, but the Prosecutor General's Office in Mexico decided not to act against the people involved in the scandal because they claimed that they did not have enough evidence, and they actually said that the Brazilian prosecutors had not turned over sufficient evidence. This was not entirely truthful. Now, this is kind of tricky. The Prosecutor's General Office in Mexico underwent a bit of a transformation in form and in function, and is now known as the Attorney General's office broadly. Their functions or their work is the same. The office has changed in their rules and in their organization, but their function is the same, to defend the people against crimes. Okay. In addition to changing names, in between 2018 and 2019, rather in December of 2018, Mexico changed president. And the outgoing president belonged to one party, and the incoming president, our current president, belongs to a different party. So many changes in the structure, the public structure of the administration of justice. Since then, the Mexico State Attorney's Office, the Mexico General Attorney's Office has somewhat changed their tune. They are no longer claiming that Brazil hasn't shared information with them, but their version today is that Brazil will not deliver the information because Mexico refuses to sign an agreement. Now, this is kind of interesting. When Brazil undertook the investigation for Lava Jato, including Odebrecht, the Brazilian prosecutors decided to sign an agreement with every other prosecutor from all the countries where Odebrecht was being tried or allegedly committed acts of corruption. And that agreement essentially said, we will turn over any evidence that we have. We, Brazil, will turn over any evidence that we have to you. But in return for that, you have to promise not to prosecute the executives of Odebrecht in your country because they are already being prosecuted in Brazil. This sounds iffy, this sounds sketchy, but it really isn't. It's actually, although it's a fairly novel provision, it's not exactly unusual. It does make sense from a legal standpoint because they would be guaranteeing that their nationals are only being tried for crimes in their country. Now, this does not exclude Odebrecht from prosecution, and obviously it doesn't exclude or liberate from prosecution the public officials in each country. In our case, Mr. Lozoya. So it is not exactly a weird or unusual contract, and it's not unfair. But Mexico has refused to sign this agreement. Why? Because they claim that they want to reserve to themselves the right of prosecuting these people. In appearance, they are saying to the public that they want to fight impunity. But in reality, in fact, this refusal to sign the agreement, the cooperation agreement, is just another obstacle, and the result is pretty much the same that we had with the previous government. No official action is being taken by the Mexican government. This even gets worse because there are international mechanisms outside of this agreement with which Mexico could obtain the information that it wants. So why isn't the Mexican Attorney General's office using those mechanisms? They have offered no justification. Further, it gets worse. Between January and December of 2018, still the previous government, the state's attorney's office has refused on 3 occasions to make public the investigation docket for Odebrecht. This is kind of tricky. They are claiming that the Odebrecht docket, or the investigation, should be reserved because it pertains to national interest. However, the Mexican Freedom of Information law does not preclude that and very explicitly states that only information can be reserved except in cases involving corruption. So it doesn't really have any legal grounds. Further, between October 2018 and February of 2019, already with the new government, with the new party in power, the individual attorneys, state's attorneys in charge of the investigations, have requested constitutional review or started constitutional review actions protecting themselves or requesting protection from constitutional tribunals against the order to disclose the information. Now, to recap briefly, when a person requests constitutional review under what we call amparo, they are in essence saying to the judicial authorities, to the courts, this person is violating my human rights. Here they are claiming that the order to disclose the investigation docket, the Odebrecht investigation docket, violates their individual human rights because it is forcing them, in effect, to violate a different law, which we have already established is not true. Again, many different legal obstacles, but the result is the same. No action is being pursued. And this is kind of interesting, or this is tricky, because for several years, and since the beginning of the Jato case, we had people in Mexico involved in this corrupt scheme. And it sort of made some semblance of sense, or at least it was rational to understand. It was understandable that the party in power will not deliver its own people to justice, right? You know, cronyism and all of that. However, the current government, the government that started in December of 2018, actually campaigned on the platform of fighting corruption. And one of the main things that the new president has said is that transparency aids in the fight against corruption. However, when we talked in this case about transparency, the government has refused to disclose information to make them transparent, and currently is doing, apparently, in effect, it's doing everything in its power not to do anything, not to bring these people to justice. The result, even though the speech appears to favor transparency and anti-corruption, the government's actions very clearly make a statement against it. The result is that no action is being pursued against these people. Okay, so let's move on to the typology. As you know, a typology is a model or an iteration of something. So in the case of corruption, a typology for corruption are the concrete steps that one person would take to commit a corrupt act. Now today, yes, this kind of maybe sort of a little falls under the header of a typology, but it's actually more of a definition or general definition that we use all the time in anti-corruption, and it is relevant to our case piece of news. We have talked many times before about what corruption is. Corruption is the abuse of an entrusted position to create an improper benefit. Okay, we have talked about grand corruption, which is, you know, corruption when it's committed against the human rights of a certain group, and when the act of corruption entails a violation worth over roughly $10,000 US. We've also talked about petty corruption, which is the corruption that people do, you know, everyday, general, minor acts of corruption. We've also discussed facilitation payments, and facilitation payments are corrupt payments made to receive what you already are entitled to. Okay, so today we get to talk about political corruption because it's very clearly related to our case. All right, so political corruption is the manipulation by a public servant of public policy, of public institutions, or of public procedural rules, the rules of the game, right? And they do this manipulation in order to create the improper benefit of maintaining power, status, or wealth, or a combination of the three. Now, so you know you are facing political corruption when you find a public servant that is somewhat, in any particular way, either by act or by omission, manipulating public policies, which is the way in which a government does things, the general philosophy behind, you know, the general philosophy of action of a government, institutions, the actual entities of the government, and the way these institutions act, or procedural rules, which are again the rules of the game, the legal rules of the game. When you find a public servant manipulating any of this, you are in effect looking at political corruption. Now, the three choices that we have for motivation of political corruption is the maintaining wealth, maintaining power, or maintaining status. In our case, in the case that we discussed, we already know that the public actors involved in the situation are already in power. Their term just started. The new government's term just started. We know that their status is in a way intact because, again, they just came into power. So what are they trying to maintain? It is a question that, it's best left for you to decide. Okay, so thank you for joining us. This was The Wife of Caesar. Again, we were very happy to have you. If you have questions, if you have comments, do me a favor, write us up in the comments, or you can find us on social media, and we'd love to hear from you. As usual, I will leave you with this. Corruption has to be reported. Every act of corruption has to be denounced, and you please do blow the whistle, but do so safely. If you're facing something and you're not entirely sure whether or not that's corruption, or you're not absolutely certain that you are personally safe, don't do anything and reach out to someone who might be able to help you figure out what to do. If you have any questions on that, please feel free to write us at info@streiner.mx, and we would be happy to help you in any way we can. Again, this was The Wife of Caesar, and my name is Michel Levien, or Michel Levien, either is fine. And thank you for joining us. Happy Monday.